Hello, wonderful people. How are you doing? I hope you're good. I hope you're fine. I hope you're doing well in your endeavor. You're welcome to another beautiful session. This is Lawyers Info Hub. This is the Law Academy where we teach law. We help you become a better lawyer. We help you become a knowledgeable law student. We help you put in shape. We help you become an excellent lawyer. And we ensure that we share tips that will help you function in your daily life. So today we're looking at how to draft a legal agreement. How is a drafting skill class. I'm going to teach you what to put, what to ensure, you know, to what you need to ensure that is in your agreement. As a lawyer, as a law student, even though it's a litigation counsel, as an in-house lawyer, as a transactional lawyer, as a corporate lawyer, as a commercial lawyer, whatever area of law you are into, even as a student, it's important you learn your drafting skills because whether you're a practicing lawyer or not, you have to draft agreement, you have to write letters. These are part of what our career is all about. Once you're a lawyer, people know you're a lawyer, they come to you with you know a sense of or a feeling that you know everything. And as a lawyer you should know everything. Yes, a good lawyer is the one who knows where to get the law and knows how to apply the law. Now, in drafting, it's important you know the contents of what you want to write or what you want to draft. If you know the content, it helps you to put up the structure on which you lay, by the time you put in the blocks in the structure, it will build up a beautiful house. In terms of construction, I'm using that as an analogy. When you have a good foundation, by the time you start laying the blocks, it's easier, for you to have a beautiful edifice. Now, to draft an agreement, there are certain things you must note. Now, someone comes to you and say, "Lawyer, please, I want to enter into an agreement with someone. Or someone wants to, you know, lease my house. Someone wants to take an empty land that I have to do farming, and I want us to have like an understanding that he's just going to lease this house, even though maybe he's not paying or he's going to pay a little amount of money. I want us to, you know, put down our resolutions or our agreements together in a formal way." Someone can come to you and say, "Okay, um, I'm going to. Someone is giving me money, or someone is loaning me or loaning. Yes, it could be a loan. I'm getting money from a bank or from a friend, a friendly loan to support my business. I'm to pay back in 3 years. So someone is owing me, an organization, an individual is owing me. I need to write them a letter of demand. These are things you see every day in the course of your career. It is sad that even on social media, we see people post letters that were not properly written. We see people post agreements, uh, contracts, and different forms of, you know, works that were drafted by acclaimed lawyers. And you see that it is bereft of the essentials. Now, as a lawyer who is excellent in what you're doing, your drafting skills must be on point. When someone asks you to draft a letter, there are basic things you need to ask the person. They are beyond the storyline. You need to get the address, you need to know what the story is all about to help you couch the heading. Even as a young lawyer, you will be faced with, even an old lawyer, they write petitions to police, petitions to different organizations. You must be able to, if you fail to be able to couch a proper heading, many people, when many organizations, when they receive letters, they first of all go to the heading. Once they see the heading, they'll know what the body is all about. But if you cannot be, you're not able to couch the heading very well, you've missed it. Many of them do not have the patience to read through your letter. But once your caption is captivating, and it's your caption should be able to tell what the problem is. It will make the person, it will help the person, it will even draw the person to the situation on ground. Now, in drafting an agreement, for example, someone you want someone to join you to build your company. You want someone, I'm just using this as an example. You want someone to be like an advisor in the company, and that you're going to be paying this person maybe some fraction or some money for the services the person is rendering. What are you going to do? How do you start? Now, I'm using this as an example because there are different types of agreements. You have the tenancy agreement, you have the lease, the deed of lease, it could be contract, it could be memorandum of understanding, it could be depending on what you want to title it. There are various types of agreements. But agreement, when you use the word agreement, is generic. There are different types of agreement. There are several types, but I'm just going to give you a rundown of what the content is, should be. Now, you see, as much as the heading of, just like I use the letter as an example, as much as the heading of a letter is key to your letter and is very important in your letter, the cover page of your agreement is very important. The cover page depicts what the agreement or what the deed or what the contract is all about. Now, on the cover page, this is where the title of the agreement is written. Is it a deed of lease? Is it a tenancy agreement? Is it a memorandum of understanding? Is it a power of attorney? Whatever it is, that is where it is. It will be on the cover page, it will be boldly written. Now, it's not between, you know, this person and this. There are two parties. You ask yourself, who are the parties to the agreement? Is it an artificial person? Is it a juristic person? Is that just an individual? Now, if it's an individual, two individuals are involved, you write the names of the parties between this and this. Now, I'm not just writing the names of the parties, you must be able to state their nomenclature. Is it between landlord and tenant? Is it between purchaser, seller and buyer? Is it between vendor and vendee? Is it between partner A and partner B? Is it between the company? You must be able to give the parties their nomenclature. In the sense that what I mean nomenclature is the first party you write there, you must state who the party is. Is it the person selling? Is it the person buying? Is it the owner? Is this if it's a hire purchase agreement? Is it the hirer? So the nomenclature of the party, the first party is key. It shows what the agreement is all about. Beyond writing the or couching, the writing the name of the agreement on the cover page, then the parties must put in their nomenclature. It's also important you state in brief underneath the parties what the agreement is all about. You can write tenancy, or if it's a tenancy agreement, for example, you write after you've seen the parties, you write in respect of block or flat 4 of number so, or in respect of 3-bedroom flats situate at number so. You can also say with respect to plot number, if maybe you're buying the land or something, but you have to, underneath you should have a little description of what the agreement is all about. Very important. Then at the tail end of the cover page should be, you have to note who prepared the document. Prepared by. It's also important to note under the parties. Let me not forget this part. Under the parties, if for example maybe it's for the agreement is deed of assignment and the assignors are 5 people or 10 people, you must list all of them. If it's a company, you state the name of the company. If it's a business name, You state the name of the proprietor trading under the name and style of. You must understand who is the person, either the seller or the first party. So understanding who the first party is helps you to know how to couch it. Now, at the tail end, you put prepared by, you put your name if you're the one preparing. Now, in Nigeria, all over the world, if it's a lawyer or an attorney that prepares a document, that should be something to show that this person is a licensed attorney. Because I know that my viewers are of mixed jurisdiction. So, if depending on what's obtainable in your country, if it's in Nigeria, for example, I'm in Nigeria, I have to write my name or write my name, write my, the name of my company or the name of my firm, put my address, put my phone number, put my email address. Then I have to put my seal. But in other jurisdiction, that could be a license number or how you stamp your document to show that it originated for or was made or it was prepared by a lawyer. Now, in now the main document, you state this agreement, if it's a deed of assignment, this deed of lease, this memorandum of understanding, whatever it is made on dash day of dash. Between, this is where you now state the parties, you state their addresses. It's very key. And just like I left told you, if it's a company, you state the company, the business name, you know how to put it out. If it is an individual, you state the names of the individual, state their address. And you know that after their names, you state their designation or their nomenclature. They're the assigners and the landlord, then of the one part. And remember that whatever agreement, depending on the type of agreement, you need to state that the agreement transcends beyond that person, where you say it includes the heirs, assigns, legal representatives, personal representatives, depending their heirs, to show that this agreement transcends this person. So that peradventure, that person is no more, you can still lay claim if they are, the contract or whatever you're transacting transcends or goes beyond that person of the one part. And the languages differ depending on what you're drafting. And you state the name of the second party, just like the same way, state the address and state of the other part, state the assigns, include the assigned, the representative, under it. Now, the second part is the reciter. What is the reciter? Reciter is where you now tell the story. For example, if it is the issue of land, if it's the issue of land, this is where you now state how the assigner or the seller of the land, you know, how he got the land. This is where you state the history of the land. You trace the root of title if it's the issue of land, you know, and if it's like a normal tenancy agreement, you state that the landlord is the owner of the building and has agreed to let the property to the tenant. Depending if it can maybe a hire purchase agreement, you state the particulars of the vehicle that is subject matter of the agreement. Depending on the nature of what you're drafting, this is where you state the history, a little bit of what the agreement is all about, how the person maybe owns the money, or the person has money and wants to support this other person's business. This is the research, just where you state the jinx of the agreement. It's also important to note that in agreement, you need to state the authority. That the fact that both parties are, that those parties do not have anything that is impeding them from entering into that agreement. Where you go and enter an agreement with the child without the guardian, it's not going to work. It has to be through the guardian. So that authority in the agreement shows that both parties do not have any impediment. They have what it takes to enter into that agreement, and that the agreement shall be binding. Now, Now look at the consideration. If there's a consideration, there's a sale, the money you should, that's where you now put in the consideration, where you state how much the property is worth. For example, if it's a property issue of a deed of assignment or all that, or if it's a share of tenancy agreement, you state how much the rent is worth and you state the duration. You know. Now, so if there is no consideration, that's also where you draft it without consideration. But this consideration aspect is key depending on what you're drafting. Note that when I mean agreement, is generic. So then you look at the terms and condition. Every agreement should have the terms and condition. What are the terms? These are part of what you discuss with the parties or whoever you're representing. They'll tell you, okay, this is in payment. I'm going to pay this. We find out that do not have the power or the authority to sell. What happens? So this is where condition. It's also important you put in indemnities and warranties. Indemnity indemnities and warranties. Okay, this the warranties. You say the indemnity or what if there's a default, goes wrong, I'll be indemnified. So that warranty is key. It's very very important in every agreement. The governing law in the issue of dispute resolution, where example what law will govern this contract, what law agreement, where there is a dispute, how can we resolve dispute? Issue of referral to arbitration. Do we resort to arbitration first before litigation? This is because it's every agreement. The fact that parties should resort to is key. It's a very vital part of an agreement that parties should resort to arbitration. Which arbitration law governs? Is it Nigeria country? Is it international? Arbitration. So whatever it is, you note it there. It there, and you know the point. You also put amendment, that where there is need to amend the agreement, what happens? Will this one, the old one, be dispensed with, or for every amendment both parties must sign, must state to amendment. Now also look at the execution part. It's very important. Under the execution, if it's company, you know that the company seal is important. Now the director sign, director can sign. Now you also need to put picture of the parties under the execution part. Also important that the witness to witness whatever column, to witness whatever the parties are. Now the other party too, you need to state the nomenclature signed, sealed, and delivered by the within named. You put the name of the person, the nomenclature, then the witness clause, the witness part. If it's a deed of assignment, the governor needs to consent. You have to put that portion underneath it. That consent to this transaction. You put the commission of oath, commission of justice through the governor, depending on everything is dependent on the type of agreement you're doing. But the execution clause is key. This is also very important. I've noticed that many people they want to put the execution part together with the part of the document. The execution clause or the execution portion of an agreement should stand on its own. It should stand on a fresh page. It's neater and better that way. It should stand on a fresh page of your work. It should not be disjointed. One part is here, the other part is in the next. So you arrange your work in a way that the execution part is in together, not separated. If, for example, the one of the parties is a business name, that you need to state the name of the proprietor and trading under the name and style of this. So your understanding of the parties, who they are, how to know them is key. How to write them is very key in your agreement. Let me also note that as a lawyer, as a law student, if you have a client or you have a brief to do to draft something, you can ask for precedents. We in this practice, precedent is cool, it's good, but it does not mean that you will not copy the precedent what word for word. Sometimes you see that the wordings in the president does not really fit into what you want. You have to change it. You don't have to do the lame dubbing or the copying. The president can give you an idea of what the structure of the agreement should be. It's not for you to fit it into what you want. Yes. And in drafting, you use modern words. There are some archaic words, hereunto, here, all those words. The word is changing, the word has even evolved. So you use modern words, simple English to be well understood. Because if the agreement is not understood, interpretation is now a problem where there's an issue. When you're drafting and there's need for someone to spell out, he's going to pay in installment within 3 months. State it, not just say within 90 days. If it's a day thing, let the person know that your client, tell you if it's within pay within 90 days. If it's going to pay 3 months, you have to be all this specific when to pay. If it's like a hire purchase agreement, for example, the person is supposed to pay on the 20th of every month. State it, not just at the end of the month. If the person is going to pay at the first day or the first working day of a new month, a new week in the new month. All those things state, you have to be clear on it. Then, if it's, for example, I'm just using this hire purchase agreement, you need to state the particulars of the vehicle. This is where you put under the recital and all of that. So you need to understand what the agreement is all about, so that the features of that type of agreement will be will be seen, so that you won't be using words for a deed for maybe power of attorney. The nomenclatures are different. You have the do not, do ni. So you ask yourself, what agreement exactly am I doing? Am I going to draft? That will help you understand the nature of the parties and how to go about it. Drafting is key for every lawyer. We must sharpen our drafting skill. And another thing most people do is that when they draft, they just feel, it's okay, it's okay. You can give to a colleague to look at it again, because having the second eye, you see, the colleague can see things you're not seeing, but for you, you think it's okay. There's a room for proofreading. Review your document before you send out. Let two people review, for another person can review for you. You also go through it again, so that it will be thorough, no mistakes. Sometimes when people copy precedents, they forget to change the things in there to reflect to what they want. And when you send it out, the client will be like, what is this person saying? And if it's a client that is not learning, they'll just take it and it will be to the peril of your client. So let's be careful. Let's do things the way it should be done, and let's improve our drafting skills. Yeah, let's improve our drafting skills. Sometimes someone want to do something, and there's no precedent. You know that you can get an old precedent and now restructure it to fit into what you want. So the work of a lawyer, it should not be your work should not be reliant on what is available. Even if it's not available, you create it, because we are innovators. We are very creative people. So, friends, it's been a wonderful time discussing with you on how to prepare an agreement. The other videos on the channel, we've done several topics. Check the channel, go through the channel, look at the videos, drop your comments, share the content, because I know that it will help someone out there. Let people know about Lawyers Info. If you've not subscribed to this channel, please, I don't know what you're waiting for. Please hit the subscribe button so that you'll be notified whenever we drop a new video. Do take care of yourself, and also know that you can always be the best. You can always improve yourself. Stay blessed and stay safe. Thank you.